Can I just say something about Andrea?
Welcome back, everybody. In this last week of January, we had a whole bunch of developments in the case against Luigi Mangione. I'm going to be breaking them down bit by bit so that we can get a fulsome view of what exactly has transpired, what the reasoning is, and what potential impacts the decisions may have down the road. But I want to first give you just the overview of what happened. So on Friday, we got a whole bunch of decisions. We got a decision from the federal court that is, in general, throwing out the death penalty, which is what we're going to be looking at in this video. We had a decision upholding the search of Luigi's backpack, which we will look at in a subsequent video. We also got Luigi's supplemental brief following the suppression hearing that was held over the weeks in December in state court on the motion to suppress there. So we will go ahead and take a look at that as well. But then we also got news that a hearing is being scheduled for next Friday in state court. A little bit confusing what that hearing is actually going to be about, because there is some indication in some of the docket reports that it's a rescheduling of the May hearing date that was set for the court to announce its decision on the motion to suppress. But it seems highly unlikely that this Friday is going to be the court announcing that decision. And the main reason why is because they've only just started the briefing. And you may remember that the state never filed any briefing at all in its initial response in the state court. It just said, we consent to have a hearing on this. So the state's never actually asserted any grounds or legal argument for why they think these searches are okay, or what law applies, or anything like that. And it would be quite unusual for a court to just invent those reasons for it without notice to the defense, opportunity to respond, and things like that. The whole point of having these types of briefing structures is so that the parties can lay out clearly what their positions are and what support they have, and everybody is on notice and has the opportunity to respond to the other party's side. So it would be quite irregular in this situation for the court to just summarily decide the issue without even requiring the state to go on record about why it thought that the search was okay, or give the defense an opportunity to respond to those specific arguments. So my suspicion is that the Friday hearing is going to be about the state's request to set an early trial date. We got news out of the federal court that they intend to start jury selection in September. And then, because now the death penalty is off the table, it's currently scheduled to start the actual trial in October. So the state is saying, we want to go first. We want you to go ahead and set an accelerated trial date for us in July. And their argument is, well, the motion to suppress will be decided in May, and then that will give time for the parties to kind of know what they have to work with in terms of presenting their cases and defenses. So that should be fine. The defense is saying absolutely not. There's no way that we would be able to be prepared with a federal trial in September. We are going to be, focusing all of our attention on preparing for that. So that's not realistic. I suspect that dispute is what is going to have to be worked out. It may be complicated in terms of the timing by the prospect of a federal appeal from the prosecution on this decision that we're going to be looking at that takes the death penalty off the table. They have 30 days to decide if they want to seek interlocutory review of that decision. Now, seeking it doesn't mean you'll get it, but is potentially something that would delay the process if they were to pursue that. So if that happens, then we kind of have a little bit more breathing room for the state to potentially schedule its trial, and then the federal trial can proceed whenever any appeal is resolved. That's my expectation for Friday. We'll see what happens. I'll be watching the same folks in court that the rest of you have been as well. So I'm going to turn now to the decision to throw out the death penalty. And I wanted to go over this in a little bit of detail, although maybe not too much detail, but a little bit of detail, because it's really very difficult to understand if you are not molded in the morass and the sometimes just bizarre process of federal criminal law. Now, I, as you know, am not a federal criminal lawyer. I don't handle federal cases. Nevertheless, this implicates an issue that I have had to encounter on multiple occasions. This is now a form of reasoning that even state-level criminal practitioners have to deal with because it is implicated in immigration consequences. And the U.S. Supreme Court has held that all criminal defense attorneys, including state-level practitioners, to be effective and to give effective assistance of counsel to non-citizen clients, you have to be prepared to provide advice about potential immigration consequences of a conviction. And that process of figuring out immigration consequences of a conviction involves this same convoluted logic that we are about to take a look at. Now, in many ways, this opinion is kind of remarkable because the judge is really telegraphing, like, she understands the whole world is going to be looking at this decision. It's a big decision. Consequentially, I mean, arguably the only reason they tried to do this prosecution in federal court in the first place was so they could pursue the death penalty. So the fact that that's being taken off the table, it's going to make waves. And so a lot of people are going to be looking at why. Why is that not allowed? And she's kind of apologetic from the very beginning about this is going to look insane, people. This is going to look crazy. It's not going to make any sense. Sorry about that. Really isn't my choice. This is what the law requires. And so I have sympathy for her because, yeah, I definitely understand the perspective that this is convoluted. So we are going to go take a look at it so that you can get a taste of not just that, but also hopefully, based on this conversation, a little bit of a better understanding about why she determined that counts 3 and 4 of the indictment, the murder charge and the use of a firearm charge, didn't constitute federal crimes that could be prosecuted. And so therefore, because the murder charge was the one that had the potential to carry the death penalty, it's no longer on the table. So Margaret M. Garnett, U.S. District Judge, writes, Defendant Luigi Nicholas Mangione is charged in a 4-count indictment with interstate travel for the purpose of stalking Brian Thompson, causing his death in violation of 18 U.S.C. sections 2261A1A and 2261B1. Count 1. Use of electronic communication systems for the purpose of stalking Brian Thompson, causing his death, in violation of 18 U.S.C. sections 2261A2A and 2261B1, count 2. Murder of Brian Thompson through use of a firearm during and in relation to the stalking crimes charged in counts 1 and 2, in violation of 18 U.S.C. section 924J, count 3. And use of a firearm which was brandished, discharged, and equipped with a silencer during and in relation to the stalking crimes charged in counts 1 and 2, in violation of 18 U.S.C. sections 924C1A 1, 2, 3, and C1B1, count 4. Now, I hate federal statutes. I absolutely hate federal statutes because they always do this. They have like a gazillion subsections and subsections of subsections, and it just makes them so difficult to read. You need like a map to navigate some of these statutes. I'm going to show you. We'll get to the federal statute here, and I think you'll probably see what I mean, but we won't quite get there yet. The crimes charged in counts 3 and 4 require that the stalking crimes in counts 1 and 2 meet the federal statutory definition of a crime of violence as a matter of law. The defendant has moved to dismiss counts 3 and 4 on the ground that this requirement is not satisfied. For the reasons set forth below, the motion is granted. This judge, in my view, has done such an excellent job of just trying to, with clarity, sum up what the reasoning pathway, the logical pathway to the decision is here. But if you're not a lawyer, this might be a little bit difficult to follow. So this is where I'm going to go ahead and take us over to 18 U.S.C. Section 924. This is the basis for counts 3 and 4 that he was charged with. The murder charge is count J. So we're going to have to scroll, as you can see, really, really difficult to find and navigate. We need to find the small j. Okay, we're at E, F, G, H, J. Here we go. Got to look for the small one. You get confused with the big one. The numbers get involved. These things are so complicated. Oh, and of course they like to reference each other. So you gotta map through the statute to know what it is you're talking about. Here's the federal murder charge. And the reason why this matters is because murder, just in and of itself, it isn't a federal crime. Most crimes are not federal crimes. The default is that law and order is something that's like a general safety, public safety issue that is handled by the states. And federal crimes only exist when there is some particular federal interest that's at stake. And that is considering the enumerated powers, limited powers that Congress has under the Constitution. So the most common one for that is interstate commerce. Most federal crimes have some type of hook to interstate commerce. That's why we end up with things like wire fraud, because it uses interstate facilities of communication to commit the crime. So murder in and of itself, just a state crime. It's got to have some connection to federal interests for it to be prosecuted in federal court. Here is the justification. A person who, in the course of a violation of subsection C, causes the death of a person through the use of a firearm shall, 1, if the killing is murder, as defined in section 1111, which basically is just an intentional killing of another, be punished by death or imprisonment for any term of years or for life. So this is our crime. In the course of a violation of subsection C is what's doing the majority of the work here. The causing the death through the use of a firearm when it's an intentional killing of another person. So we also have to prove this violation of subsection C. So let's go back. My eyes are crossing a little bit, trying to find C. That's a big C, not a small c. Okay, here's C. Except to the extent that a greater minimum sentence is otherwise provided by this subsection or by any other provision of law, any person who, during and in relation to any crime of violence or drug trafficking crime for which the person may be prosecuted in a court of the United States, uses or carries a firearm, or who in furtherance of such crime possesses a firearm, shall, in addition to the punishment provided for such crime of violence or drug trafficking crime, be sentenced to these other terms depending on the facts of the case. In this case, discharged to a term of imprisonment by not less than 10 years. Okay, so breaking this down again, right? So any person who is during and in relation to a crime of violence using a gun. If you're using a gun during a crime of violence that is a federal crime, then you can receive this additional punishment. And if in the course of doing this crime of violence in which you're using a gun, you kill somebody intentionally, it's federal murder. So this is why the crime of violence provides this hook here. It's right there in the statute as one of the elements that the state is, or that the prosecutors are going to have to prove in order to justify a federal conviction here. So going back now to our opinion, okay, we can conclude what they've said is that the crime of violence that is otherwise federally prosecutable are counts 1 and 2. The stalking charges, use of electronic communications for purposes of stalking and interstate travel for purposes of stalking. Those are both justified federal prosecutions because they have federal interests. Interstate travel, electronic communications, and interstate communication system. These are things that the Congress can legitimately work with. But for these other crimes to be prosecutable, has to be in the commission of these. These have to be crime of violence, and they're independent elements using a firearm and in so doing intentionally causing the death of another human being. And the court has found they fail on this crime of violence element. So these stalking charges, they can be federally prosecuted, but they are not crimes of violence. So now we got to talk about why. And the why is where it gets really convoluted. And the why is where the court is going to get a little apologetic to us about why. So the case will proceed to trial on counts 1 and 2, which charge the defendant with causing Brian Thompson's death under 2 federal stalking laws. Those ones are okay, legitimate federal hook. And they don't themselves require a crime of violence, right? It's not a definition, an element of those crimes. It's an element of the use of a firearm, the reason why the use of a firearm in the murder are justified as federal crimes. So they themselves are fine. The potential maximum punishment for each of those offenses is life in prison without parole. Count 3 is a capital eligible offense on which the government filed a notice of intent to seek the death penalty. Consequently, the chief practical effect of the legal infirmities of counts 3 and 4, and this court's decision that they must be dismissed, is solely to foreclose the death penalty as an available punishment to be considered by the jury that will otherwise determine at trial whether to convict the defendant for causing Brian Thompson's death. So without a death penalty eligible charge, you can't seek a death sentence. And the only one that was eligible here was the murder charge. And that's pretty consistent with constitutional limitations on use of the death penalty, 8th Amendment case law that requires that the death penalty can only be imposed for murder. There was, now I don't remember the name of the case, but some years ago, Kennedy versus Louisiana, maybe, the one that held that for non-murder charges, including things like rape, child abuse, stuff like that, cannot support the imposition of the death penalty as a matter of constitutional law. So only murder, and the murder's out. So no death penalty. That's the bottom line. So she's got to explain the reasoning now. The question before the court is whether, under the relevant statutes and Supreme Court precedent, the crimes charged in counts 1 and 2 are crimes of violence. Sounds like a very easy question to answer, doesn't it? You would just look at, what are we saying Luigi did? He stalked him to kill him, right? That's the allegation. Luigi found out where he was going to be and had a purpose and an intent to end his life and carried that out. That's the basic allegation that the government is making. Seems intuitive, but that's not how the analysis goes in federal court. The court would be remiss not to note at the outset the apparent absurdity of the inquiry. Court's saying, guys, I'm really sorry for what you're about to read here. because you might think this is an easy question, but it's not. The defendant is charged with selecting a stranger to be killed based on his employment, carefully planning the killing, including identifying where and when the selected victim would be most vulnerable, traveling across multiple states to carry out that killing, and then gunning down the victim on a public street in Midtown Manhattan using a handgun equipped with a silencer. The footnote here, of course, these charges remain to be proven at trial. In any event, neither the seriousness of the charges nor the strength of the evidence are legally relevant to resolving the present motion, as explained further below. He's still presumed innocent. We're here on a motion to dismiss, which means you assume the allegations are true. You assume they're true. And even if they're true, does that mean we can move forward with this prosecution? That's why she's saying it seems absurd, because if we're assuming these allegations are true, sure sounds violent, doesn't it? Sure sounds violent. But it's not going to matter. So she's going to have to explain us why. No one could seriously question that this is violent criminal conduct. And yet, over the course of the last 2 decades or so, the Supreme Court has embarked upon a legal journey, explained herein, that now requires lower courts to engage in an analysis totally divorced from the conduct at issue and centered on the hypothetically least serious conduct that the charged crime could possibly cover. This is typically shorthanded as the categorical approach. And literally, the hair on the back of my neck stands as soon as I read these words, the categorical approach. We are going to see them a lot, the categorical approach and the modified categorical approach. And so this is where state-level criminal defense practitioners run into this bizarre reasoning, because what the categorical approach is basically a situation where if federal law defines certain categories of offenses, this is the analytical process you have to go through to decide if what you're dealing with, your situation in your case, fits within that category. And it gets real convoluted. So it comes up in the immigration context because certain types of criminal offenses, state criminal offenses, trigger deportation requirements. These are categories like aggravated felonies, crimes of violence, crimes of involving drug trafficking. And so you need to understand how to look at your situation and evaluate, is this going to constitute, for example, an aggravated felony, which is one of the more bizarre ones, because an aggravated felony doesn't have to be a felony. It just has to have a potential sentence of 1 year or greater. And so it can be a misdemeanor if the potential sentence for it is 1 year. It has to meet other requirements to constitute an aggravated felony. So this is where I've had to deal with this, looking at charges filed against my clients, looking at the allegations, trying to sort out, okay, here's what he's charged with. Here's the offer that we've received. What are the potential immigration consequences of these? I got to look at potentially doing these categorical and modified categorical approaches. And they are just an area that lawyers don't like them. I don't like them because they are replete with uncertainty, as you're going to see as we go through how this analysis works and all of the many ways it can go astray. Whatever the merits of that approach in contexts that require the assessment of past state criminal convictions, e.g. the removal criteria in the Immigration and Nationality Act, which is where I deal with it, or the sentencing enhancements in the Armed Career Criminal Act, it has proven a poor fit for Section 924C and 924J, where the defendant's alleged conduct is encompassed within the indictment and full fact-finding, whether by a jury or by the court, can occur with procedural protections for the defendant. It has produced questionable results that defy common sense, e.g., this case in which arson is not a crime of violence, this case in which kidnapping is not a crime of violence, and equally importantly, has proven increasingly difficult for lower courts to apply with any confidence or consistency. These are not new observations, and she cites a dissenting opinion by Supreme Court Justice Clarence Thomas decrying the current state of the Supreme Court's categorical approach jurisprudence and urging a revival of the residual clause or a return to a constitutionally permitted conduct-based analysis. These criticisms may not necessarily make a lot of sense at this point, but hopefully it will become clear as we proceed. But certainly, I think she makes her point when she says, this test seems to defy common sense. If kidnapping is not a crime of violence and arson is not a crime of violence, then what the heck even is a crime of violence? And particularly, you know, when you're in a situation where you have a jury that's there to evaluate specific conduct. What she's pointing to are that situations when you're looking at prior convictions, which is what happens in the immigration immigration context, they don't necessarily have a transcript, have the jury, you know, have a lot of factual information about the case. Sometimes they might just have a simple paper that reflects, you know, this here's the charge, here's the statute, and this person was convicted because maybe it was 30 years ago and the underlying records are now gone and can't be recovered. So it can be a little bit of a different situation for that type of context, but she's saying, look, this is not that. We're literally here to adjudicate the facts. So surely we should be able to consider the conduct that's at issue when we're looking at this prospectively. Is it a crime of violence versus retrospectively, potentially based on very limited information? So she doesn't like the standard. I think that's pretty clear. However, regardless of its own views, a district court is duty bound to follow binding Supreme Court precedent. The analysis contained in the balance of this opinion may strike the average person, and indeed many lawyers and judges, as tortured and strange, and the result may seem contrary to our intuitions about the criminal law. This might be putting it mildly. But it represents the court's committed effort to faithfully apply the dictates of the Supreme Court to the charges in this case. The law must be the court's only concern. She's telling you right off the bat, she doesn't like that she has to do this. She doesn't like where it goes. But it's not her job to change the law. That's Congress's job or the Supreme Court's job, you know, to the extent it's a matter of interpretation. And so she's going to do her duty, be a faithful servant of the tools that are handed to her, implement them faithfully, and don't like it, guys. Don't look at me. I'm just the messenger here. In this case, count 3 is charged under one of the few murder statutes available under federal law, 18 USC section 924J. Here's this footnote that elaborates most murders are charged under state law in state courts. Federal prosecutors and thus federal courts have jurisdiction only over those murders that can be charged under a handful of federal criminal statutes created by Congress. Section 924J, murder through use of a firearm while engaged in another specified type of federal crime, is one such statute. Count 4 charges a related statutory subsection, 924C, which criminalizes the use, carrying, and possession of a firearm during one of those federal crimes, but stops short of murder. The analysis in this opinion as to count 3 applies equally to count 4, even though the latter does not charge murder. The analysis is the same because they both require the use of a firearm in the course of committing an independent federal crime that is a crime of violence. So 924J is the murder statute. That statute requires the government to prove beyond a reasonable doubt that the charged murder was committed during and in relation to a different federal crime, and that different federal crime must be a crime of violence. Crime of violence is defined under federal law as a crime that has as an element the use, attempted use, or threatened use of physical force against the person or property of another. Here, The specifically alleged predicate crimes of violence are the stalking crimes charged in counts 1 and 2. In his motion to dismiss counts 3 and 4, the defendant argues that 1. The question of whether the stalking crimes in counts 1 and 2 are crimes of violence as a matter of law must be analyzed using the categorical approach. 2. Section 2261A is not divisible into separate criminal units, and accordingly, the modified categorical approach does not apply. 3. Even if the modified categorical approach did apply, neither Section 2261A1A or 2261-2A requires the government to prove as an element the use, attempted use, or threatened use of physical force. And 4, because the stalking statutes encompass threats to self-harm, so long as the perpetrator is a family member or intimate partner of the stalking victim, they do not necessarily require using force against the person of another, as required by the definition of crime of violence. Does that make sense? Crystal clear what this is all about? Real clear. She's outlining the way that the defense has presented, the argument, the issues in this case, by kind of outlining a little bit of an overview here of how this analysis works. When you're looking at whether something fits within the category of offenses that Congress has defined, you start by looking at, is the statute indivisible? And if so, you use the categorical approach. But then if it's divisible, you use this modified categorical approach. And it changes the analysis significantly. And what those things mean, divisible, indivisible, this is where the frustration for the judges and the lawyers and the unworkability and so forth that she is complaining about, this is where those things arise, because it is often less than crystal clear. So not really surprising that this, doesn't make a lot of sense, because we're not super grounded yet in what those things mean, but we'll get there. In response, the government, 1, agrees that for counts 3 and 4 to stand, counts 1 and 2 must meet the statutory definition of crimes of violence. So we have to show they fit within this category. We got to use one or the other of these tests, categorical or modified categorical. We just don't necessarily know which one. 2, agrees that the categorical approach to that inquiry is mandated by Supreme Court precedent. 3, contends that at a minimum, Section 2261A is divisible into 4 distinct criminal units, A, B, C, 1A, 1B, 2A, and 2B. And thus the modified categorical approach must be used to analyze only the specific crimes charged here, which are 1A and 2A, combined with the penalty provision in 2261B. 4 argues that both of those crimes require the government to prove beyond a reasonable doubt that a defendant used, attempted to use, or threatened to use physical force against the person of another. 5, to support that argument, that the court should read a mens rea of at least knowledge into the key element of the statute. And 6, that the statute cannot be read to include self-harm. A lot of arguments here, not necessarily clear why any of this matters. Have faith. Have faith. It will come together. I can't promise it's going to make sense, because that would require, internalizing this analysis and why we're doing it in the first place. But hopefully, as we get into it, it will make a little bit more sense about why the court says things need to be looked at this way. Each of these arguments is analyzed at length below, but in sum, the court finds 1, that the stalking statute is divisible into 4 distinct crimes. 2, that accordingly, the modified categorical approach must be used. 3, that neither of the charged stalking crimes necessarily requires the government to prove use of force as the Supreme Court has defined it, in large part because the only element that could potentially satisfy that standard can be committed recklessly, which does not meet the standard. 4, the penalty element of death resulting does not change the analysis because it likewise does not require the necessary mens rea, mental state. And finally, 5, in the alternative, the pertinent element can be satisfied through threats of self-harm, and thus the requirement that the use of physical force be against the person of another is not met. For all of these reasons, the stalking offenses charged in counts 1 and 2 are not crimes of violence as a matter of law, and counts 3 and 4 must be dismissed. So this is like a nice roadmap of the logical progression here. It's just that this is such a convoluted analytical format, that it's still, I mean, I'm sure, I'm quite sure that a lot of you watching are like, what on earth did we just say? What did we just say? What does this even mean? I'm going to try to break it down as best as I possibly can, just in very general terms. It's got to be a crime of violence. And in order to be a crime of violence, it has to have as an element the use, attempted use, or threatened use of physical force against the person or property of another. So the bottom line is that what they're going to be doing here is looking at these statutes, these subsections that Luigi is specifically charged with, and see, is there an element in these statutes that requires the use, attempted use, or threatened use of physical force against the person or property of another. If any of the elements in those charges include this, then we're good to go. But if they don't, we're out of luck. She is concluding that we are out of luck because the elements of those statutes do not include necessarily in all circumstances the use, attempted use, or threatened use of physical force against the person or property of another. So hopefully this is starting to become clear why this is a little bit of a counterintuitive analysis, because it doesn't consider the conduct itself except in a modified way, which we'll talk about when we get to that section. This is considering what's charged in the abstract because it's based on having an element. Okay, it has as an element. And so what the Supreme Court has essentially said is that in order for something to have as an element, it means that that crime must always, in every iteration, require this: the use, attempted use, threatened use of physical force against the person or property of another. And so if there is any way that the crime could be committed, given how it's defined under the statute, that does not involve use, attempted use, or threatened use of physical force against the person or property of another, then it's not going to count. Even if, in this particular case, what is charged would involve threatened use, attempted use, actual use of force, physical force against another. Does that make it a little bit more clear, like why this is a bit of a brain twister when you get into this modified and categorical approach? It's because the actual allegations matter very little to none. The only way they matter at all is when you get into this modified categorical approach, and just for purposes of establishing which elements are we going to be looking at here. We are looking at the elements of the charge completely in the abstract, and we are imagining circumstances. And all our job as a defense lawyer, if I want to show it doesn't count, my job is just to imagine a scenario where somebody could violate this crime and it wouldn't meet this condition. That's it. And as long as I can imagine it, even though that's not what's charged, then we're out of luck. So that's the weird, out of touch, counterintuitive, not going to seem logical basis, the reasoning, the apology that the district court gave. That's why, is because we're not looking at the concrete conduct at all. We're looking at hypothetical situations. So that was her conclusion. Based on that, she is concluding that there are hypothetical ways that both of the stalking charges can be committed that would not involve the use, threatened use, or attempted use of physical force against the person or property of another. So first, the legal standard on the motion to dismiss. We already know it's not about the evidence. It is literally just about legal issues. You presume that the allegations are fine. It's purely a legal dispute as to whether they satisfy the statutory definition of crimes of violence such that they can, as a matter of law, serve as the predicate offense for counts 3 and 4. What is a crime of violence? The statutory scheme. Counts 3 and 4 are both charged under Section 924 of the Criminal Code, which sets forth various laws that criminalize use of firearms in connection with another federal crime that is a crime of violence. There's a footnote here that it can also involve a drug trafficking crime, which we saw when we looked at the statute, but that's not an issue here, so we're not going to talk about it. Count 4 is charged under Section 924C, which criminalizes the use, carrying, or possession of a firearm during and in relation to any federal crime of violence and contains escalating penalties if the firearm is brandished or discharged. Count 3 is charged under 924J, which criminalizes causing the death of a person through the use of a firearm in the course of violating Section 924C, and contains escalating penalties if the resulting death would constitute murder under federal law, in which case the penalty can include any punishment up to life imprisonment or death. In other words, both count 3 and 4 depend by statute on the commission of an underlying crime of violence that is independently cognizable under federal law, and that the government must prove beyond a reasonable doubt as an element of the Section 924 offense. So we're going back to the definition. We already saw it. Felony that has as an element the use, attempted use, or threatened use of physical force against the person or property of another. I'm going to be like spitting this out by rote before we're done with this. Say it so many times. Put differently, I love how she rewords things. You know, she does. She simplifies, and it's a very good explanatory opinion as these types of things go. I find it very courteous when a federal judge speaks to a broad audience and doesn't just assume, hey, you know, the only people that are reading this are going to be the people that are already deep in the morass of federal criminal practice, and so already know how frustrating and obnoxious and difficult these particular standards are, and I don't necessarily need to explain it to them, so I can just go through it, and it sounds, you know, it sounds abstract and complicated and difficult to people that aren't already swimming in that pond. But she knows this is going to have a broad audience, and so she's gone to, I think, quite a bit of effort to try to simplify and explain this process in ordinary terms as much as possible. So put differently, crimes of violence under Section 924 must be felonies that, by definition, involve force. She is simplifying that whole use, attempted use, or threatened use of physical force against the person or property of another. She's just going to call it force throughout the opinion, so we don't have to keep saying that over and over again. Although the statutory language does not define physical force, the Supreme Court has held that it means violent force. That is, force capable of causing physical pain or injury to another person. So just a touch, something that is not going to hurt you is not going to satisfy this requirement. It's not just anything. It's got to be potentially harmful or injurious in order to be violent force. This force can be direct or indirect. That just means I can do it myself with my own body, my own hand, or I can do it through another instrumentality. I can throw something at you. I can, you know, I don't know, a remote control tank, send it at you. Something that is not me or in my hand, but I'm indirectly causing this to be done. In addition, Supreme Court case law requires that the element that satisfies use of force must be committed with a mental state that is greater than recklessness. So these are the nuances now that make it more than just using force. There has to be a mental state. If I just negligently, you know, I've got a knife in my hand and I'm like engaged in a heated conversation and I turn around real quick and somebody's standing behind me and I stab them, that's negligence, right? I didn't intend to do it, but I was quite careless, and you shouldn't wave knives around. That's dangerous. So it's the type of thing that you shouldn't do. That's not going to count as violence. It's not severely egregious. I mean, it's bad, but it's not on the same level as like I'm intending to stab somebody, and so I take the knife and I put it through them. It's not the same as I take the knife and I throw it in that direction, knowing that it's highly likely going to hit you and cause you injury. Or it's different than we're having that heated conversation and I get mad and I stomp off and I've got this knife and I'm angry, so I throw it on the ground on my way off. I'm stomping off. Throw it down on the ground and it goes through your foot. That's probably reckless because I should have known, like, you're right there. We just had this conversation. I am potentially putting your physical safety at risk with my actions, but I disregarded it. I did it anyway. That's not going to be enough. Okay. Neither the negligence nor the I don't care, but it happened. And I should have known that was a likely consequence. Those aren't enough. It needs to be more targeted, more directed, more focused, more done with a purpose of the intent of carrying it out. So not just any force, purposeful, desired force. The categorical approach and the modified categorical approach. Oh, now we get our analytical background, and welcome to hell, guys. To determine whether an offense is a crime of violence under the Elements Clause, courts employ what has come to be known as the categorical approach. This inquiry does not ask whether the particular defendant used force or violence in committing the specific crime he is charged with. Indeed, such an inquiry is expressly precluded, and the real-life facts of a particular case must be ignored. Rather, the only relevant question is whether the federal felony at issue always requires the government to prove beyond a reasonable doubt as an element of its case the use, attempted use, or threatened use of force. With all of those clarifications about what that means that the court has already established. The rationale behind the categorical approach is not exactly intuitive. It begins with the Supreme Court's holding that offense, as used in Section 924C, has only its abstract meaning, meaning it refers to a generic crime. So in Section 924C3A states that the term crime of violence means an offense that is a felony and has as an element the use, attempted use, or threatened use of physical force against the person or property of another. It does not call for an examination of the specific acts in which an offender engaged on a specific occasion. Instead, the inquiry is limited to whether an offender has been charged with a crime such that, as defined in general for all possible cases, inherently meets the force requirement, such that the government must always prove beyond a reasonable doubt as an element of its case that force was used, attempted, or threatened. A court undertaking the categorical approach must identify the minimum criminal conduct necessary to meet the elements of a particular offense, examine the least serious way, the most minimal conduct that you can engage in that would still constitute a violation, and then evaluate whether that least serious hypothetical conduct, not the defendant's actual conduct, necessarily involves force. At times, the inquiry is relatively straightforward because the statutory definition of the crime in question contains words that on their face have an equivalent meaning to use of physical force against another. More commonly, the process resembles a sort of stress test, where the task is to probe the boundaries of the offense to find examples of conduct that might fail the definition of crime of violence, but nonetheless satisfy all of the elements of the offense. I like that she uses the stress test because that really kind of is what it is. Like in engineering, the stress test is when you build your thing and then you destroy it. And you are essentially doing this to measure, the amount and force and direction, of the different forces that that your design can withstand. Kind of what you're doing here with imagined crimes. You're just you're imagining. You're subjecting the statute to hypotheticals that are, less and less and less serious, that take all of those elements and look at them in the least incriminating possible way, so that you would still get a conviction, but is it gonna pass? Is it gonna pass that violence requirement? If this inquiry reveals that the offense could, in at least one conceivable factual scenario, be committed without force, then the offense is not a crime of violence in any case, regardless of how obviously violent a particular defendant's alleged conduct may be, because the government could prove that hypothetical case to a jury and secure a valid conviction without having proved that that hypothetical defendant used force. This is probably like one of the clearest and easiest to understand explanations of the categorical approach that I think I've ever come across, honestly. Like if I were teaching a CLE or something like that, like lawyer's education for, here's how you have to approach evaluating the immigration consequences of the charge your client is facing or the offer he's received or anything like that. Read this case to understand what that means, because I think it really does break it down in a way that's easy to understand. We're not looking at the actual conduct. We're looking at abstractly the crime itself and the elements of the crime, and we are imagining scenarios that fit within those elements. So you can take the charged conduct out of it altogether. And so that's what ends up being a lot of the work at state level criminal prosecution in, immigration advisement, is that you're looking for crimes that don't satisfy any of these deportation criteria. It's not an aggravated felony. It's not domestic violence. It's not drug trafficking. It's not involving moral turpitude, because it could be committed in ways that don't count. And so it's fairly common to have like a little bit of a database almost of like, here's crimes that either have already been looked at legally and determined they don't satisfy, or we've gone through and we've done the analysis and here's the imagined way that it doesn't work. So this is an immigration safe charge. And then you work towards, can I get a deal for my client if my client is a non-citizen? And non-citizen does not mean illegal, guys. It does not. That's part of the issue. It means you can have a green card. You can be a lawful permanent resident, be here for many, many, many years. but you pick up one of these deportable offenses, you're gone. You're out. If ICE comes to get you, you are getting deported. So want a person with a green card to be able to get a second chance, be able to find redemption, change and improve and grow and so forth, and do that in the United States, you look for a plea resolution to a crime that satisfies this categorical approach. So that's the broad analysis of what it involves. Now we got to look at the modified categorical approach and how this tweaks it a little bit and how this intersects with that annoying tendency of the federal statutes to run on and on and on and on and have all of these different subsections and subsections and so forth. Some crimes can be committed in multiple ways. For example, the federal kidnapping statute can be violated by seizing, confining, inveigling, decoying, abducting, or carrying away and holding a person for ransom. The categorical approach demands that a court conduct the crime of violence inquiry using the least serious or least violent way of committing the crime, the minimum conduct necessary to be convicted. So all of these different ways, which one is the least serious? Seizing, confining, I'm not even entirely sure what inveigling, isn't that like enticing? Decoying, abducting, or carrying away and holding another person for ransom. I'm going to go with this enticing, inveigling, because that's the one where I'm going to be able to imagine lots of ways that could be done without threatening physical force. I think there's a lot of ways potentially that could be done without threatening physical force. And the example that just pops right to the front of my mind, there's a trial that they're waiting to get started over there in Arkansas, the trial against Aaron Spencer, who is accused of killing the man who had been grooming and abusing Aaron Spencer's daughter since she was, 11 or 12 years old. She was 13 years old at the time of this murder. And so Aaron Spencer is claiming self-defense because on the night in question, his daughter was missing from her room. Parents discovered it. They went out looking, and he discovered that she was in the car with the guy that, the creep who had been abusing her. And he basically followed the car, eventually ran it off the road. Seems like the allegation is that the creep got out of the truck and began to approach him, and Aaron Spencer then shot him to death multiple times. And so the basis for self-defense in that case is that you're allowed to defend yourself or others in the state of Arkansas using deadly force if you are responding to basically the commission of a felony. And kidnapping in that case is a felony. Well, we don't have any evidence that the creep held a knife to her or anything like that. But the problem is that they had this, he had groomed her. This is a disturbing and I don't know, just very, very complex experience for prepubescent. It's typically pubescent or prepubescent children. And what it's essentially, the studies about grooming are about, how are adults able to kind of get these children to engage in activity that they are not mature for. They are not benefiting from. They're literally like not made to like it at this point. They're not developmentally there yet. And so it's this, manipulative process. Like I said, it's been very well studied, and it's a lot of gifts and manipulations and keeping secrets and pushing boundaries and getting the child accustomed to escalating levels of touch and things like that. So it's a mind game. It's a mind control game. There's no I'm forcing you to do it. It's a different and much more insidious type of process. So that's exactly the thing that came to my mind, looking through these options. Inveigling somebody for kidnapping, yeah, it kind of sounds like what that groomer does to that kid. And so if it doesn't necessarily require that he held a knife to her or threatened to hit her or something like that, he just warped her mind so that she thought this was normal and okay. It's probably not going to fit that crime of violence. And so that is why you have that counterintuitive decision that she pointed out earlier up in the opinion that said kidnapping is not a crime of violence under this analysis, because there's ways to commit it. We just imagined one. Ways to commit it that don't involve threat of physical force. So when there's lots of ways, you look at the least violent way under this categorical analysis. Conducting this inquiry is easiest when a defendant is charged under a statute that clearly defines a single crime based on one indivisible set of elements. Sometimes, however, a statute sets out one or more elements of the offense in the alternative, effectively defining multiple separate crimes, some of which might satisfy the crime of violence definition, and some of which might not. This is the means versus the elements analysis. And this is where statutory interpretation often gets very convoluted and not very clear, not very predictable. Because look, these are alternatives, right? It sets out one or more elements of the offense in the alternative. And the alternative usually means this or this or this or this. You're looking for that or. But we have an or up here. Seizing, confining, invading, decoying, abducting, or carrying away and holding a person for ransom. There's the or. Any of these ways could constitute. And so what you're going to find is that if the or means it's just a alternative means of committing one singular crime, we're fine. We're still in the categorical. But if that or means we're actually talking about two separate crimes now, we're in modified categorical. And so how do you know what the or means? Not always clear. This is getting into the heart of like why this is, it's just not a good standard from a rule of law standpoint, because part of the reason you have law at all is so that it's predictable. So you know that you're dealing with, you know what a judge is going to say. And when there's all this ambiguity about how do I interpret this or, there's just a lot of opportunities to get it wrong. And then when you get it wrong, you're giving bad advice. People are doing things based on your bad advice. They are then being surprised by the outcome. You are being surprised by the outcome. The court might come back and reverse it. It's just like it creates a lot of this unpredictability that it's not what you want a rule of law for. A rule of law is supposed to be about stability and about order, not about chaos and confusion and situations changing and so forth. So when you have to evaluate the legal significance of or, and a lot depends on it, is that really a great test? Is this kind of or is it that kind of or? For example, a battery statute might contain one part that covers mere unwanted touching and another part that covers the intentional infliction of bodily harm. Even where the more serious of the two options is the basis for a defendant's charge, under the categorical approach, the offense might fail because it could be committed under the less serious option. If these are two battery crimes and not just different ways of committing the same battery crime, If a statute with multiple alternatives is divisible into, in effect, separate crimes, a court may employ the modified categorical approach to determine whether it may disregard the uncharged alternative formulations of the statutory crime. So when you have this one complicated federal statute with like 10 subparts and 20 subparts of those 10 subparts and et cetera, and some of the ors are divisible and some of the ors are indivisible. Following me? When it's divisible, you ignore the ones that are not charged. And you only look at the one that is. So if murder, I see, and it's like so hard. It's so hard to even come up with an example off the top of my head because it just gets so convoluted. Well, let's just continue because she's doing a very good job of making sense out of this in the best way I think that she can, because she knows that there are going to be a lot of people reading this that aren't lawyers, and even a lot of the lawyers and judges are reading this are going to be like, you got to be shitting me. You're telling me this is the law. It really is. But so this is the bottom line. If it's divisible, one statute, multiple crimes, we only look at the crime that's charged. And this is the limited place where we can look at the allegations, because that will help us clarify what exactly is charged, which subsection here is charged. If all of these different subsections are just alternative means of committing one crime, then we look at all of them. We look at all of them in the least serious way of violating all of them. We pick the least serious one and find the least serious way to evaluate it, and that is our basis for our categorical approach. So the reason why I suggested this might have a little bit to do with the convoluted federal statutes that we get is because it kind of benefits them in this analysis, right? If you want the charges, if you want basically broad charging authority and for lots of things to fall within this category, then you make them divisible so that you have to look at each and every individual one. If you make them indivisible, now you're in this situation where it doesn't matter what this particular guy did. You can only charge him with the one thing, and then you have to look at the least serious way of committing that thing, and the least serious set of facts that would satisfy it. So there's a little bit of an incentive built in if your goal is to perpetuate criminal convictions, which our system kind of is, and certainly legislative motives rarely tend to be soft on crime. It's not let's be soft on crime. It's like let's make more and more things criminal. Let's make penalties more and more stringent and so forth. Although there has been a little bit of change in that maybe in the last decade or so, but by and large, the goal is more prosecution and more convictions. Then it might help you to make these things more divisible so that there are just more targeted ways to evaluate the seriousness of the conduct. Whereas the categorical approach forbids court to look beyond the statutory definition of the charged offense, if a court determines that a charged statute is divisible into multiple different crimes, the modified categorical approach allows courts to consider a limited class of documents, including the indictment, to determine what crime with what elements the defendant has been charged with. If the indictment specifies the relevant alternative set of elements, the court proceeds with the categorical approach as if that set of elements were a standalone statute. Thus, the modified categorical approach serves merely as a tool for implementing the categorical approach in certain cases. The modified categorical approach likewise does not permit consideration of the defendant's actual conduct. So I guess I might have said that badly given how she says it, but your conduct, the alleged conduct, is what forms the basis of the specific charge. And so with the modified, if it's a divisible statute, we get to look at which version of the statute, and that's going to depend on what are the specific factual allegations against you. But other than that, your conduct, other than the extent to which it determines which subsection is at issue, we don't consider the allegations at all. Elements versus means. This is where it gets real fun. It gets real fun. Not everything in statute. This is the or. Which or are we talking about? Are we talking about an or that establishes elements, or are we talking about an or that establishes alternative means? And this comes up in a lot of different contexts too, far beyond this categorical approach. This can come up in double jeopardy analysis. It can come up in jury unanimity issues. Lots of ways this can come up. Not everything is a statute is an element of the crime. Elements are the constituent parts of a crime's legal definition, the things that the prosecution must prove to sustain a conviction. Statutes often include verbiage beyond the bare elements, spelling out various factual ways of committing some component of the offense. These legally extraneous circumstances are called means. Got it? Got it? Is that clear? She'll do better. To convict a defendant of a crime, a jury must unanimously conclude that the government has proven each element of the charged crime beyond a reasonable doubt, but jurors need not unanimously agree on statutory words that are only means. This is how jury unanimity gets implicated. If you got an or in there that establishes elements, they have to be unanimous. But if the or just establishes different ways of satisfying the same element, then they could disagree on which way, which thing the defendant actually did, as long as they all agree at least one of those was satisfied. When applying the modified categorical approach, the difference between elements and means is crucial for determining whether a statute can be separated into multiple crimes. The modified categorical approach applies only to the extent a statute is divisible, and a statute is divisible only to the extent it lists alternative elements and not means. A fact always qualifies as an element which must be found unanimously by a jury beyond a reasonable doubt if it changes the statutorily prescribed punishment for the crime. So this is one of the ways you can identify an element is it changes the punishment. If committing the crime one way is one crime and you get maximum of 10 years in prison or something like that, but then you throw in doing it with a firearm and now the sentence goes up to maybe 25 years. Then using a firearm is going to be considered an element for that purpose. That one is a pretty easy one to spot. The other ones are not always. If we go back here to this example, the federal kidnapping, I can already tell you these things are alternative means. These are understood as alternative means of committing the same statute. They're not separate elements. If you put it just like this in your indictment and in your jury instructions and so forth, and some people thought, yeah, I think he did use physical force, and other people thought, no, I think he just used his mind games. I think he manipulated this person into complying. You're still going to get a kidnapping conviction because they don't have to be unanimous on which of these means was used to commit it. Is it clear why those are means and not elements? Not to me and not always. Perhaps it will become a little bit more clear as she gets into addressing this particular set of charges. The indictment in this case identifies the interstate stalking offenses charged in counts 1 and 2 as the predicate crimes of violence required for counts 3 and 4. Just one of them needs to qualify as a crime of violence for counts 3 and 4 to survive. As set out above, the first step in answering this question is to determine whether the stalking statute is divisible, and if so, to what degree. Both offenses are defined in Section 2261A of the Criminal Code, which provides whoever, 1, travels in interstate or foreign commerce with the intent to kill, injure, harass, intimidate, or place under surveillance. Okay, we have an or right here already. Okay, so are we dealing with means or are we dealing with elements? Or place under surveillance with intent to kill, injure, harass, here's another one, or intimidate another person, and in course of or as a result of such travel or presence engages in conduct that A, places the person in reasonable fear of the death of or serious bodily injury to 1, that person, 2, an immediate family member, 3, a spouse or intimate partner, or 4, the pet, service animal, emotional support animal, or horse of that person. Now, does a horse not count as a pet? I guess a horse doesn't count as a pet. My livestock doesn't count unless it's like a pet. If my chickens, do my chickens count in here? I don't know. If somebody threatened my chickens, they consider my pets? I'm not sure. Anyway, or here's another or. So that was A. B, causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress to a person described in one of these clauses. So 1, 2, or 3. It doesn't include the animals on this one. If you just intend to stress out my chickens, then we don't have a question at all. But, so this part, the travels with the intent of doing certain things, and as the result, we have these alternative outcomes here. Reasonable fear of death or reasonably expected to cause substantial emotional distress. A lot of ors to have to sort out. And then we have subsection 2, with the intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate another person uses any electronic communication system of interstate commerce to engage in a course of conduct that A, places that person in reasonable fear of the death or serious bodily injury to a person, pet, service animal, emotional support animal, or a horse, described in these same clauses. Gets convoluted, right? Travels in interstate, uses electronic communication. Otherwise, we've got a lot of overlap as far as these intentions go, and then the outcomes that result. Or B, causes, attempts to cause, or would be reasonably expected to cause substantial emotional distress to a person described in these same clauses. Shall be punished as provided in section 2261B. Okay, so let's work through this because we've got all kinds of different alternatives here, right? We got a lot of different alternatives. When are these different elements, and when are they just alternative means of committing the same crime? Subsections 1 and 2 each provides an alternative basis for federal jurisdiction. Subsection 1 criminalizes stalking through interstate travel, and subsection 2 criminalizes stalking through any electronic communication system of interstate commerce, such as the internet or texting. So these are counts 1 and 2, travel stalking and cyber stalking. The government and the defendant agree that subsections 1 and 2 define 2 different crimes, and thus 2261A is divisible into at least the 2 separate crimes of travel stalking and cyber stalking. So we're divisible at least on this level, 1 and 2. What about the rest of this? Are these alternative means or are these different elements? Aside from the different jurisdictional threshold, and that's how we know, because different, in this particular case, they're saying, we agree they're different crimes because they have different jurisdictional justifications, different jurisdictional hooks, as you might say. So different reasons for Congress having a particular interest here that justifies federalizing this criminal activity. Aside from the different jurisdictional threshold, subsections 1 and 2 of Section 2261A are largely the same. Both require that a defendant's interstate travel or use of interstate communications be undertaken with a certain malicious intent toward another person, to kill, injure, harass, intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate that person. So, mental state, they share the same mental state, and both require that a defendant engage in conduct that produced a certain result, either A, placing the targeted person in reasonable fear of death or seriously bodily injury to themselves or to any of a list of proxies, such as an immediate family member, partner, or pet, or B, causing substantial emotional distress to the targeted person or to one of the proxies, or attempting to cause or reasonably being expected to cause such emotional distress. So these are the outcomes. We've got intent and outcome. The court will refer to subsection A as the reasonable fear subsections and to the subsections B as the emotional distress subsections. Travel stalking and cyber stalking both carry the penalties defined in an adjacent section of the criminal code. If the death of the victim results from the offense, the defendant may be sentenced to life in prison. The question of whether travel stalking and cyber stalking are further divisible into resulting harms, i.e., into travel stalking by reasonable fear, travel stalking by emotional distress, cyber stalking by reasonable fear, and cyber stalking by emotional distress, as the government argues, is crucial to the crime of violence inquiry, because if the statute is not further divisible, the emotional distress subsections would be the least serious formulation of the crime. In other words, okay, go back to the statute. You do this conduct. Reasonable fear of death or serious bodily injury to a person, pet, or service animal. Do you need some kind of violence to do that? Some threat, at least use, attempted use, or threatened use of physical force to put you in fear? Reasonable fear of death or seriously bodily injury? Probably yes, because it's a general predicate that words alone are not going to be enough. Words plus conduct can be, but much stronger argument here for necessarily involving physical force. But causing emotional distress is kind of different, because that's, it seems to kind of be the distinction between, words hurt people's feelings. That's why people are assholes with their words. Like that's the outcome that you're seeking to achieve. So a lot of ways you can achieve emotional distress without inflicting violence. So that's why this is a really important distinction, because if this is all one crime, okay, we've already said 1 and 2 are separate, but if this is all one crime, then all we're finding the least serious formulation, this one right here, and we're imagining, is there a way that somebody could travel in interstate commerce with the intent to do these things? Okay, what's the least serious formulation? Intent to place under surveillance with the intent to harass them. And in the course of that, as a result of such travel, engages in conduct that would cause them substantial emotional distress. Yeah. This is things like, I travel interstate, I show up at your place of work, I show up at your house, I follow you in my car. The presence alone, it's not violent. It's not use of force, certainly not explicitly, but it's going to be very emotionally distressing to the person who's targeted by that. So it's going to satisfy the elements of this crime. You could be convicted of this crime for doing that, but it doesn't involve any violent force. So if we're looking at this whole statute as one thing, we're done. Like, we can stop right there, because substantial emotional distress isn't going to get you over the hurdle. That's basically what she's saying. Because the government concedes that the emotional distress subsections would not qualify as crimes of violence, that would end the inquiry. The court has little difficulty concluding that the stalking statute is further divisible by the resulting harm provisions, as argued by the government. So we have separate crimes now based on the outcome. We already have separate crimes based on you traveled versus you used the web or whatever. And now we're going to have further different crimes depending on, were you trying to place them in fear of bodily injury, or just make them sad, make them upset, make them anxious. First, subsections A, reasonable fear, and subsections B define alternative elements. That seems conclusory, doesn't it? Like, that's the question. How do we know that they define additional alternative elements? The reasonable fear subsections cover any conduct that places the victim in reasonable fear of the death or serious bodily injury to the victim or related persons or animals. The emotional distress subsections cover any conduct that causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress. These provisions set forth two alternative elements with distinct requirements, not merely two different ways to complete some other unspecified element of the stalking statutes. We don't know why. I'm not sure she even knows why. If she knew why these are different alternative elements and not just alternative means of the same crime, she could tell us. She could tell us why. But there's no why in here. There's just, it is, and here's the situation, and it is. So this is quite frustrating. It's not necessarily helpful to anybody that needs to engage in this analysis as part of their legal practice. Doesn't tell us, how does this judge think, so that when I am making an argument in front of her, I understand her framework for distinguishing between these are elements and these are alternative means. We don't know. She just said, in this case, this is what they are. The defendant counters that anyone who reasonably fears death or serious bodily injury would necessarily also feel substantial emotional distress, and that if one alternative is essentially a complete subset of the other, then that typically indicates means rather than elements. But it requires a strained reading of Section 2261A to treat fear of death or bodily injury as merely an example of substantial emotional distress. Defendant's interpretation would make each reasonable fear subsection a pointless inclusion, since the emotional distress subsections would cover the universe of prohibited harms. Under ordinary statutory interpretation rules, a court does not lightly assume Congress adopts two separate clauses in the same law to perform the same work. So the fact that they're like related, the court is essentially saying, well, they're different enough, and they have to be interpreted a way that respects that they were set out separately. By setting them out separately, Congress expressed its intention that these are not the same thing, because they just presume Congress is not repeating itself unnecessarily. It's not including superfluous language. If all it cared about was people being sad in various formulations, it would have just said that. So by virtue of setting out reasonable fear and emotional distress separately, assumes that Congress meant separate things. Furthermore, by their structure and text, the reasonable fear subsections and the emotional distress subsections address different harms and require different proof. Sections 2261A1 and 2 each present their reasonable fear and emotional distress provisions in parallel subsections, with no indication that both subsections belong to some overarching elemental category, in contrast to the nearby references to killing, injuring, harassing, or intimidating another person, for example, which are textually linked to an overarching element of the necessary animating intent of the perpetrator. Do you understand that distinction? Is that crystal clear? You got that? I sure don't, because we can just go right back to the kidnapping statute that we already know sets out alternative means. Convey, abduct, inveigle, whatever they all were. Congress said all those things separately, did they not? Did they not? And yet that wasn't enough to make them elements. Present their reasonable fear and emotional distress provisions in parallel subsections with no indication that both subsections belong to some overarching elemental category. What she's essentially saying is that if you look at the structure of the statute, this part is in common to all of these options. This part is in common with, all of those options. But these are separate. If, for example, they had put it as, I don't know, if they had reorganized the statute, whoever does all of these things and as a result, places the person in reasonable fear of death of or causes or attempts to cause substantial emotional distress to 1, 2, 3, 4, these people. A, travels in interstate or foreign commerce, or B, uses any electronic communication system of interstate commerce, then it would be different. Then those would be like the only distinctions that really mattered. That's how this court is kind of ruling, because even though these things are pretty much exactly the same between both of those statutes, right? They're pretty much the same thing. Congress spelled them out twice. Instead of just structuring this whole statute as one thing with the only distinguishing thing between them being the obvious, one is interstate travel and one is electronic communication. That's the reasoning, okay? It's not in common, even though they're exactly the same thing, because Congress said it twice instead of making it some kind of overarching part. Now, does this seem to you like this is perhaps reading an awful lot into the thought process of whoever wrote this statute in the first place and gave it to Congress to vote on? I mean, we already know they don't read the bills. Some of these bills, there's absolutely no way that the Congress people could read them, the entire thing, before they get voted on. So these bills are written by staff people, not the legislators themselves, and yet we just infer all of these things from decisions that might very well be arbitrary, or they might be time driven because we needed to push this statute through, and so we didn't have time to get it through another set of editing and refinement and restructuring and reorganization, and as a result, we wrote these things out twice. Had we edited it better, we might have gone ahead and incorporated it under one. And there are so many downstream consequences here in court based on assuming that that was a purposeful decision and not just an incidental consequence of the process of this particular piece of legislation being enacted. So I kind of have to feel like that plays into the perception of this process being a little bit absurd and counterintuitive, because it's assuming so much purpose on the part of Congress that pragmatically, I think we kind of know that's unlikely. But that's the reasoning. That's the reasoning. Okay. No overarching elemental category. Congress said it twice instead of just one time. The subsections have other relevant differences as well. Under the reasonable fear subsections, the stalking victim is the only person whose fear matters, and the fear must be objectively reasonable. It suffices that the victim reasonably fears the death of a family member, a partner, or a pet, but the mental states or knowledge of those third parties are irrelevant. Meanwhile, the emotional distress subsections have no required reasonableness limitation, and the element can be satisfied by the emotional distress suffered directly by the third party proxies, excluding the animals, including attempts to cause such distress. These distinct legal requirements signify alternative elements, not means, because they establish different things the prosecution must prove to sustain a conviction. Now we got a because here, okay? Because is an answer to a why. It's an explanatory offering, but it's not real helpful, is it? Because the things, different things the prosecution must prove to sustain a conviction would also apply to this, right? Different things. Intent to kill, intent to injure, intent to harass, intent to intimidate. Those are different things the government has to prove. This test becomes guesswork very, very quickly. And I hope it is starting to become clear why. Okay. Lost track of where we were because I've been scrolling back and forth so much. Accordingly, here's her conclusion. Section 2261A is divisible into 4 crimes. 2261A1A, travel stalking reasonable fear. A1B, travel stalking emotional distress. A2A, cyber stalking reasonable fear. And A2B, cyber stalking emotional distress. So got that? This one, 2261A, sets out 4 crimes. 4 crimes, and everything else in those statutes presumably are just alternative means of committing the same crime. And why? Well, at the end of the day, because this judge says so. Can't necessarily give you a lot better reason than that. Structurally, little bit of differences in the outcomes that she described. This one, all we care about is the target, but you can place the target in fear of harm to somebody else. This one, emotional distress can be inflicted on anybody else as long as they have that relationship with the target. So the outcome is different enough that it justifies the different crimes. The travel, doing it by travel and doing it by cyber stalking are different enough that it constitutes different crimes. But why is it not different enough to intend to harass somebody versus intend to physically harm them? Your guess is frankly as good as mine. The government also urges that the 2 reasonable fear subsections are further divisible into subsections 1, 2, 3, and 4. They want everything to be this. This is where the law often gets amusing and entertaining because it's very contextual. It's very contextual. In this context, the government wants to divide up the statute as much as absolutely possible. And that's so that the universe of least serious ways of committing the crime is limited. It's as limited as it can be. The more distinct and defined the crime is, and the more we've gotten rid of all of these other requirements, better chance they're going to have of being able to pass this categorical test. But that's this context. If we were looking at, for example, a jury verdict and how this is all, written out and what specifically the jury has been told it has to find unanimously and what it doesn't, the government will be taking exactly the opposite position in that litigation, because then it would want all of these things to be alternative means so that you don't have to have jury unanimity on any of them. And in fact, it would want this entire thing. They would want all of this to be alternative means. If it was if the jury just got all this, scroll, the jury just got all this, literally this, in an instruction, and says, find beyond a reasonable doubt this unanimously. And you, the defense lawyer, are going, wait. What exactly did you find in terms of the facts? What did you find unanimously? Did you find they traveled, or did you find they used electronic communication? If these separate elements, it has to be specified. You have to know they found that unanimously. So in that context, the defense is going to argue every single one of these is an element, separate, distinguishable. And the state is going to be arguing, no. These are all just alternative means, so that one guilty verdict to the whole thing is enough. It's funny how law is motivationally driven like that. Just a lot of the decisions that you get are kind of a product of serendipity. Is not necessarily the right word, right? Because it's got that positive connotation to it. It's like a good thing that circumstances unfolded the way they did, but just matters of timing and so forth. It's coming up in this context here, and not in a context where a jury verdict, unanimous decisions are being presented. So this is the context in which the government has to take a position, and therefore circumstantially this is the position that they're taking, and then here's how the law evolves based on that position. And having taken this position, now down the road, should the jury verdict issue come up, we're going to be pointing back to this and saying, you already said these are different elements. You already said these are alternative means. So it's just kind of funny how that works sometimes. So the government wants to divide it up more. They contend that each reasonable fear subsection splits into separate crimes according to whose death or injury the victim fears. The court cannot join in this extra step. These Romanet subsections identify alternative means for satisfying the fear of death or bodily injury element, rather than alternative elements necessary for further divisibility. No because here, just that's how it is. The government correctly notes that when provisions are set apart by the disjunctive phrase or, you got an or, in separate sections and subsections, it is at least indicative of divisible elements. But unlike the reasonable fear and emotional distress subsections, the provisions in subsections 1 through 4 fall under a single overarching element, placing the targeted victim in a qualifying state of fear. And all 4 provisions work exactly the same way. They identify different qualifying objects of the victim's mental state of fear. Just as a perpetrator may use a deadly weapon by employing various kinds of instruments, the means, a stalker's conduct may place the victim in a qualifying state of fear, the element, by targeting various categories of people and animals, the means. So this is the closest thing we've gotten to a dividing line, a real analytical distinction between what is an element and what is a means. And so it's done by analogy. It isn't done by giving us an explanation of a general rule, which is how law usually is created and perpetuated. It sets up rules, general rules, and those rules are then applied to different factual circumstances, and you get an outcome. It would make this a lot simpler if we just had a nice rule that said, here's what makes a thing an element, and here's what makes it an alternative mean. But we don't have that, and no judge really has come up with that in a very clear and workable and usable universal way. I think that's a big piece of it, is because once you make it universal, you're stuck with how it applies in every situation. And so it limits your ability to make an exception or find a little bit of a different reason or wiggle around it if perhaps you think a different outcome is more appropriate. Not really how the law is supposed to work. But when you're dealing with judicially crafted law, it does kind of make sense that they would keep their own future flexibility kind of in mind as a consideration, that it would motivate how they approach these kinds of issues. Because this one's a real morass. Okay, coming up with a general rule for when or means one thing versus when it means another. We can do it by analogy. We've said these things use a deadly weapon, okay, I guess because it's broad, is the element, by employing various kinds of instruments, the means. It's one way of distinguishing, but it's not really spelled out in a way that allows us to do anything other than just kind of continue to analogize this to different situations that get presented, and then we may or may not be right about how similar or different we think they are. The government's position also clashes with 2261A's logic. If subsections 1 through 4 were divisible, each subsection would create an independently chargeable offense. But it makes little practical sense that a single course of conduct would constitute a varying number of stalking offenses depending solely on whose death the victim feared, particularly since, as discussed below, a defendant need not intend this particular result to satisfy the element. It also makes little textual sense. For example, a victim's spouse is a qualifying person under both subsections 2 and 3, yet no reasonable construction of the statute would permit a single course of conduct that caused fear of injury to the victim's husband to be charged as two separate crimes, once for his role as an immediate family member and a separate count for his role as spouse. This is getting into double jeopardy considerations. Double jeopardy is not a particularly protective doctrine, as I'm sure anybody who has followed this case for a while has kind of figured out. Double jeopardy means you can't be charged with the same crime. But what constitutes a same crime is essentially, whatever Congress says are different crimes. It's become a matter of statutory interpretation. They look at the elements. The elements test is it's not Brandenburg. I've spaced on the name of these things. Haven't dealt with this particular one for a while, but same elements. As long as Congress has set things out with different elements, then it's fine. It's two different crimes, and even if your conduct is exactly the same, you can be charged for two different variations of it. The different evidence test. Does it require exactly the same evidence to prove that somebody is an immediate family member as to prove that they're a spouse? No, if you're coming at this in a double jeopardy type of context, you're going to say the one is broader than the other. You can prove that somebody is an immediate family member, with all kinds of different facts. But you can only prove that somebody is a spouse by proving that marital relationship. So they're different elements, different evidence required. Same act, but you could be charged for different crimes. So it's one of the considerations that comes into all of this, and I will say it is nice to see a judge express some concern for the prospect of just infinitely dividing statutes for purposes of being able to multiply charges against an individual for the same thing. So that's part of her reason for why it's not separate elements. It would make it too easy to charge people with multiple crimes. Along similar lines, finding that subsections 1 through 4 are divisible as separate elements would necessarily require a jury to unanimously agree on which subsection the defendant violated, which finds no support in the law. The harm in the reasonable fear subsections centers on the targeted victim's fear of death or bodily injury, not on the precise object of that fear. Subsections 2, 3, and 4 introduce third-party proxies, but they do not shift focus from the victim. Rather, they evince Congress's recognition that a stalker may seek to coerce a victim not only by targeting the victim directly, but also by exploiting the victim's relationships with loved ones. Manipulation. They'll use manipulation and threats and triangulation of the people that you care about just as much as they will with you personally. But treating those subsections as alternative elements on which the jury must have unanimity cuts the other way, potentially hindering prosecutions where the stalker uses vague threats or instills diffuse fears. If, for example, a man sends messages to his ex-girlfriend threatening to kill her precious little baby if she does not take him back, is a jury meant to return a not guilty verdict if 6 of its members believe the victim only feared the death of her child, and the other 6 believe she only feared the death of her beloved dog? The court thinks not. It's a conviction, production system. So can't make it too hard to convict. The court thinks not. Subsections 1, 2, 3, and 4 merely define alternative means, and they provide no basis for dividing 2261A1A and 2A further. So having decided the statute is divisible, the modified categorical approach applies. So I'm going to start to kind of go over this a little bit more broadly because we already know some of this stuff. So consequently, in conducting the crime of violence analysis, the court need not consider the emotional distress subsection. And the only relevant evidence are those that comprise the reasonable fear versions of travel stalking and cyber stalking, plus the element that death of the stalking victim results. The court must then ask whether to prove either of those 2 crimes. The government must prove beyond a reasonable doubt as an element of its case the use, attempted use, or threatened use of force. Section 5, neither charged stalking offense is a crime of violence because any force element can be committed through reckless conduct. Let's parse out what that means, because this is really the driving basis for her decision that these stalking charges don't qualify. So first, identifying the relevant element, defendant argues that the crimes charged in counts 1 and 2 cannot be qualifying crimes of violence as a matter of law, either because no element requires the use, attempted use, or threatened use of force, or to the extent any element does, it is one that can be committed through conduct that is merely negligent or reckless, which falls below the level of intent or knowledge necessary to constitute the use of force under Supreme Court precedent. Remember the difference between I just casually toss a knife to the side as I'm leaving. I don't even know anybody's there. I know you're there and I throw it down, and I'm not necessarily trying to hit your foot, but I know your foot's there and I could hit it. Negligent, reckless. I throw it knowing that you're over there and that there's, a pretty good chance if my aim is good and I throw it hard enough that I'm going to hit you. And then I, literally come at you and On purpose, make sure that you intersect with my blade. These are the mental state requirements, and only those last two are going to count. So the defense is arguing that to the extent any of these elements require force, it's the kind of force that involves the throwing it aside or the just not really caring. And I know you're there, but harm results. So to determine whether the defendant is correct, we must begin by reviewing the elements. As we always do, they're essentially identical with the exception of the different jurisdiction triggering elements. So both crimes are going to be discussed together. First element, travel interstate or use an interstate electronic communication service with intent to kill, injure, harass, or intimidate, or place under surveillance with intent to kill, injure, harass, or intimidate his or her intended victim. Neither party disputes that these are alternative means. Okay, it's an or, but nobody's arguing that this makes it different crimes for whatever reason. Not sure why, but or just means a means in this case. Similarly, neither party seriously disputes that intent to harass is the least serious or least violent way of committing these crimes, or that this least serious version of the first element can be committed without the use of force. So harassment doesn't always require force. Everybody is agreeing with that. First element cannot be one that satisfies the categorical approach. Doesn't make it a crime of violence yet. Accordingly, this element cannot qualify this charged stalking offenses as crimes of violence. The next element requires the perpetrator to engage in conduct in the course of or as a result of the interstate travel or using the interstate communication service. Section 2266 defines course of conduct to mean a pattern of conduct composed of two or more acts evidencing a continuity of purpose. And although travel stalking requires only engaging in conduct, courts have noted the distinction is one without a difference. While there is no difference, no requirement of multiple acts of internet stalking, for example, 2261A requires both an act of travel and conduct, placing a person in reasonable fear of death or serious bodily injury. Nothing in this element requires that the conduct in question use force, and the government does not dispute that a range of facts can satisfy this element, including nonviolent acts such as driving to a particular place or placing a phone call. Yes, I would agree with that. So again, this is insufficient to meet the legal requirements for crime of violence. Next, the statute requires that the perpetrator's conduct or course of conduct places the intended stalking victim in reasonable fear of the death of or serious bodily injury to the stalking victim themselves or to a list of third-party proxies for that victim, such as his or her family member, intimate partner, or pet. The government argues that this element or this element in combination with or as a modifier to the required conduct, course of conduct, necessarily requires that the government prove the use, attempted use, or at least threatened use of force in order for you to be in reasonable fear of death or serious bodily injury. That is their argument. I can already see the challenge because it's outcome. We've already established these different elements are based on the outcome. And the outcome of having the knife through your foot is not what defines the mental state. So I can already see where there's a little bit of an issue here, because if it said the perpetrator's conduct or course of conduct intentionally places, we're done. We're done, because you have to have some sort of threat of force to be in reasonable fear of death or serious bodily injury. But we don't have that. So because of that, potentially in the situation where you just drop it over here and you do that over and over, and it's going to place that person in fear that their foot is going to get stabbed, but they haven't established your intent to bring about that foot stabbing. So the government concedes that the statute does not use those words or even analogous words, but rather argues that the conclusion is justified because it is impossible to imagine a perpetrator's conduct that would place the stalking victim in reasonable fear of serious bodily injury or death that did not involve the use, attempted use, or threatened use of physical force. But even assuming for these purposes that the government is correct about that as a factual matter, that does not end the inquiry. And that's because the kind of force, they both agree, a use of force element that can be satisfied through negligent or reckless conduct does not qualify as the kind of force required to make out a crime of violence under Supreme Court precedent. Negligence and recklessness are two levels of culpable mental state or mens rea where the fault lies in the actor's insufficient concern with a risk of injury. Negligence, the lowest level of culpability, involves the failure to perceive a risk. One level higher, recklessness involves the conscious disregard of a substantial risk of harm. Many crimes, but not all, require a higher degree of mental fault, either knowledge or purpose. A person acts knowingly when he is aware that a result is practically certain to follow from his conduct, whatever his affirmative desire. And a person acts purposefully or intentionally when he consciously desires a particular result. Different elements of a criminal statute can have different mens rea requirements. For example, to be found guilty of illegal possession of a firearm by a felon, a defendant must purposefully or intentionally possess the firearm. But no mens rea at all is required for the element that the firearm in question be in or affecting commerce. Not necessarily a great example, is it? But it's just saying that you don't have to know that this firearm was manufactured in one state and shipped to another. You know, when you bought it. You don't have to know that or care about it or all or anything like that. The mens rea element doesn't extend to this requirement. It just extends to the act of possession. So I'm not sure that I follow that this means different elements can have different mens rea requirements, but there can be situations where, particularly when there's multiple acts involved in a certain crime, that it can require a particularly high mental state for one, but maybe a lower mental state for a different act. In Borden, the Supreme Court held that conduct cannot qualify as the use of physical force against a person or a person of another to satisfy the crime of violence inquiry, unless the actor has a sufficient mens rea relevant to that use of force. Borden did not precisely delineate the relevant threshold, but it explicitly decided that recklessness or mental states less culpable than recklessness, such as negligence or no mens rea at all, falls short. And so there's this footnote here that just makes it clear they are dealing with a different word, a different definition, violent felony, but it's very close. Almost exactly matches the definition of crime of violence. And so it is logical to assume that the same reasoning applies. Borden was, we love plurality decisions. No, we don't. Plurality decisions are awful. It's when you don't have a majority of the court agreeing on anything except the outcome. And so understanding the reasoning for that outcome, you don't have anything that's binding because you don't have a majority of the court that captured it. 3 of them said it's for this reason. 3 of them said it's for this other reason. And 3 of them said we don't agree with the outcome at all. So what does it mean? Who knows? It means you got real unlucky with your particular issue and the context, the factual context in which it was presented. The reasonable fear element does not depend on the perpetrator's subjective intent, or at a minimum can be satisfied with mere recklessness. Because the government relies on the places in reasonable fear element as the component of the stalking offenses that could arguably require the use of force, whether by itself or in conjunction with the death resulting element discussed below. The government rightly concedes that if conduct committed recklessly satisfied the reasonable fear element, then the stalking offenses are not crimes of violence as a matter of law. Because the statute itself is silent on the mental state of the defendant that must be proven for this element, the defendant argues that reckless conduct does indeed suffice. The government, by contrast, asks the court to read into the statute a requirement that the reasonable fear element requires a mental state of at least knowledge. The court declines to do so. Although the reasonable fear element requires conduct that has the result of placing a person, a victim, in fear of serious bodily injury or death, it does not require an intent to cause that result or even knowledge that such a result will occur. We must, of course, begin with the language of the statute itself, and the government concedes that the section 2261A contains no mens rea language for these elements. In contrast, the statute does specify that the required interstate travel or use of an interstate communication facility be undertaken with the mental state of an intent to kill, injure, harass, intimidate, or place under surveillance with intent to kill, harass, injure, or intimidate another person. The 11th Circuit's decision in U.S. versus Fleury contains a thorough analysis of the mens rea required for the results elements of Section 2261A, and the court finds it persuasive. So the 11th Circuit is not binding over New York. New York is, oh gosh, am I going to just blow it now? Is New York Second Circuit? I'm pretty sure New York is Second Circuit, right? Fourth? No, fourth is Florida. I don't do federal court, so I forget sometimes. Pretty sure New York is second. Anyway, it's not the 11th. We know it's not the 11th. 11th, I'm pretty sure, is Texas. Is the 11th Texas? I don't know. Anyway, embarrassing myself now. In Fleury, the defendant appealed his conviction for cyberstalking emotional distress. As discussed above, the four distinct crimes share a like structure with three elements: jurisdictional action taken with the specific intent, engaging in conduct that causes a specified result. So three elements. Like the reasonable fear subsection, the emotional distress subsection contains no express mens rea requirement for the result produced by the perpetrator's conduct. In the statute, language reaching any course of conduct that causes, attempts to cause, or would reasonably be expected to cause substantial emotional distress to a qualifying person. The defendant's course of conduct in Fleury involved sending disturbing, taunting, and harassing internet messages to the friends. Oh, we are in Florida in the 11th Circuit. Okay, that was my bad. Taunting and harassing internet messages to the friends and family of the victims of the school shooting at Marjorie Stoneman Douglas High School in Florida. At trial, the jury was instructed that it could not return a guilty verdict unless it found that the defendant made a threat under circumstances that would place a reasonable person in fear of being kidnapped, killed, or physically injured, and that the messages in fact caused their recipients substantial emotional distress. The jury was not instructed on any required mens rea other than the intent to harass or intimidate. On appeal, here's where you get a situation where, the position that you take is kind of dependent on the outcome that you're looking for in this situation. On appeal, Fleury argued that his conviction should be overturned because the jury should have been told that to convict him, they had to find that he sent the offending messages with the subjective intent to make the recipients feel threatened, or at a minimum with the conscious and subjective knowledge that such result would follow. The 11th Circuit rejected this argument and concluded that the consequences of the conduct, i.e. the results or feelings the conduct produced in the victims, such as fear of injury or substantial emotional distress, did not have any mens rea requirement, and that Elonis versus United States did not require more because the problem identified in Elonis was addressed in Section 2261A by the requirement that the defendant travel or use the internet with the intent to harass or intimidate. I don't know what Elonis is, but it seems to have to do with the problem of strict liability statutes not having any clear mental state. Yeah, not sure. But so bottom line here is the statute does have a mental state. It just only applies to the travel or use of the internet. It doesn't apply to the consequences. So you don't have to intend the consequences as long as you intended the act that produced the consequences. Because of the parallel structure of the reasonable fear crimes and the emotional distress crimes, the 11th Circuit's analysis and flurry of what the defendant must know or intend about the results element in Section 2261A fits the question in this case equally well, compelling the conclusion that the reasonable fear element likewise does not depend on the subjective intent or knowledge of the defendant. Indeed, the government's own conduct in Section 2261A cases in this district supports the conclusion that a jury in a 2261A case does not need to make any finding about the defendant's mental state regarding the results of his conduct in order to convict. So guess what? Lo and behold, when the government wants to convict people of committing this crime, it doesn't add this into the jury instructions as something that the jury has to find beyond a reasonable doubt. It doesn't work in that context. In that context, you want it to be easier to convict them. And so you don't take the position that they have to agree unanimously that the defendant intended or at least knew the outcome was going to come about. So you don't ask them to do that. But now you're in this different context. Now you're taking a little bit of a different position. Funny how that works. She's got cited all of these government's proposed jury instructions and so forth. Yep. Nonetheless, if the government now argues that the engages in conduct element requires a scienter, it's also a mental state, of at least knowledge of the results produced, and that the court should read that mens rea into the statutory text. The government further argues that such an emendation by the court is necessary under Elanis because without it, the statute risks criminalizing innocent conduct. But because Section 2261A already requires that a defendant undertake a purposeful act with the intent to kill, injure, harass, or intimidate, and because as the conduct producing results elements of the statute, a mens rea no greater than recklessness is sufficient to separate innocent from wrongful acts, the government's argument fails. So you have to have some to keep it from the possibility that you would criminalize innocent conduct and just thought crimes, right? Thought crimes associated with something that isn't criminal. So it has to be at least reckless. It can't just be, I accidentally dropped my knife. You know, we can't just look at somebody's foot got stabbed. Even if I was mad, you know, I intentionally had the knife in my hand, but I accidentally dropped it. The fact that somebody got stabbed alone, that's not criminal. That's an accident. That's innocent conduct. So there has to be at least I knew you were there. I dropped it anyway. I knew there was a chance it would hit your foot, and in fact it did. So that's all it seems this Elanis case is saying, is that just you have to have some kind of mental state that's sufficient to make sure you're not punishing accidents. An overriding presumption in the law is that wrongdoing must be conscious to be criminal. For a given offense, the mens rea necessary to make a person criminally responsible for his or her acts is known as scienter. When criminal statutes are silent on the required mental state, meaning statutes that contain no mens rea provision whatsoever, the presumption of scienter may compel courts to impute the mens rea which is necessary to separate wrongful conduct from otherwise innocent conduct. The government relies on Elanis to argue that the court must read into 2261A a requirement that the defendant knowingly places the victim in fear. In Elanis, the Supreme Court imputed a scienter requirement into a federal statute criminalizing the transmission of any communication containing any threat to injure the person of another. The statute contained no explicit mens rea at all, making it unclear whether a conviction required proof that the sender of the communication knew the communication contained a threat. A jury convicted Elanis based on instructions that the government need prove only that a reasonable person would regard Elanis's communications as threats. These are This came up in Counterman versus Colorado to the constitutionality of harassment statutes. They have to constitute a true threat, and they have to include at least a reckless. The same thing as here. Like you have to at least recklessly communicate a threat. And it's hard for me to imagine a situation, where you would communicate a threat, but you don't know it's a threat. I don't know. The Supreme Court reversed the conviction, holding that the instructions improperly disregarded Ilonis's mental state and instead hinged criminality on what was effectively a negligence standard. Because the crucial element separating legal innocence from wrongful conduct is the threatening nature of the communication, the Ilonis court opined that a scienter requirement must apply to the fact that the communication contains a threat. I guess maybe this would be like an individual, like a capacity thing, I said something that either because I am limited in my understanding of what I'm saying, or maybe because what I'm saying means something specific to you that I don't know about. Maybe that's kind of what this is getting at, as far as knowing the communication contains a threat. Criminalizing the transmission of communications and otherwise innocent act based only on how the recipient might react without considering the sender's subjective state of mind as to the content or purpose of the communications, the court held, is inconsistent with the conventional requirement for criminal conduct awareness of some wrongdoing. Ilonis provides no help to the government here because Section 2261A already has a mens rea element delineating the culpable conduct that Congress intended to criminalize. Unlike the statute in Ilonis, which specified no mens rea whatsoever, Section 2261A explicitly requires a specific intent to kill, injure, harass, intimidate, or place under surveillance with those intents, and that the jurisdictional element be undertaken with this express and plainly criminal intent. Quite simply, traveling with an illicit intent is culpable conduct, as is harassment, which is criminalized under numerous state and federal statutes. It is neither anomalous nor problematic that Section 2261A criminalizes unintended consequences of culpable conduct. You kind of assume the consequences of your wrongful acts. Under Section 2261A, a person engages in culpable conduct when he travels or uses interstate communication with the necessary malicious and criminal intent and undertakes some conduct that furthers that intent. There is no risk that such a perpetrator somehow becomes innocent if his conduct happens to cause harm only accidentally or causes more or different harm than intended. Accordingly, it is not necessary to import a scienter into the results element to separate wrongful from innocent acts. When a statute includes both objective and subjective elements, a court need not impute a mens rea into the objective elements when the subjective element, here the specific intent to kill, injure, harass, or intimidate, suffices to separate innocent and wrongful acts. The Supreme Court has contemplated only two scenarios that may require courts to read a scienter requirement into a statute. One, where a statute contains no mens rea provision whatsoever, which calls for imputing that mens rea which is necessary to separate wrongful conduct from otherwise innocent conduct. And two, where a statute includes a general scienter provision, which calls for distributing the same mens rea to the other statutory terms that separate wrongful from innocent acts. Neither situation is applicable here. It already includes a specific provision for state of mind with which a defendant must travel or use a communication facility. And the government's argument does not suggest that scienter should be distributed to the later elements, but rather seeks to impute a different specific scienter to one of the other elements. This is going back to the firearm case that they were suggesting before, like the fact that you know that you have a firearm. You don't also have to know that the firearm moved in interstate commerce. You don't have to apply that same mental state to all of the like different elements of the charge. It only has to apply to one particular part of it. So the government is kind of trying to use this argument for when you would have to apply it to a different element, but it's not, because it's arguing for a different mental state. It has identified no precedent for doing so, and indeed there is ample reason to reject it as a legal principle. Courts do not read additional scienter requirements into statutes that unambiguously specify the requisite mens rea, i.e., when Congress expressly delineates what combination of acts and mental states a given statute is intended to prohibit. Their job is to interpret the law, not to write it. And the government here is essentially saying, court, we're asking you to rewrite the law so that it requires this element that will allow us to put Luigi to death. We really want you to do that. The legislature didn't do it, but we really, really, really want you to do it. And we don't have apparently a legal basis for saying that you should. And so the court is saying, not going to do that. Not my job. I don't write the laws. I just interpret them. If you've got a problem with how the law is written and you want to assume the burden of proving that in all your future cases, go lobby Congress to make the change. Somehow I suspect they're not going to do that. And even if there were a reason to impute a mens rea element, there is no reason at all to assume that a mental state of knowledge would be the minimum required. For all the reasons discussed above and elaborated further below, recklessness would be more than sufficient to separate innocent and wrongful acts, given that the prerequisite intent to kill, injure, harass, or intimidate another person creates responsibility for at least the foreseeable consequences of the defendant's conduct. And since recklessness is based on disregarding foreseeable consequences, you know it, you disregarded it, then that's enough to make it criminal. The death results element does not change this analysis, as it likewise has no specific intent requirement. As part of counts 1 and 2, the defendant is charged with a particular penalty provision attached to section 2261A, which raises the maximum sentence to life imprisonment if the death of the victim results from the charged stalking conduct. But once again, I don't know, somebody's behind me and I chuck the knife, and instead of hitting their foot, it's an accident. I didn't know anybody was there or even could be there. Had no reason to think that knife was going to hit a person, then it's probably not going to be criminal. The defendant concedes that this penalty provision is an element that must be proven beyond a reasonable doubt to a jury, and so the modified categorical approach requires that the court evaluate the hypothetical crime as one that satisfies this element. If it increases the punishment, it's an element of the crime. So because resulting in death means you can get death, it's an element. As to this element, the government concedes that the death can be an accident or the consequence of reckless conduct, so long as the defendant's actions cause the death. Consistent with that concession, the Second Circuit has held that a death results element requires only but for causation, meaning that the government need only prove that but for the defendant's actions in committing the charged crime, the death would not have occurred. They don't have to intend to bring the death about. Under this test, the death of the victim need not be foreseeable to the defendant, and certainly need not be the defendant's desired or intended outcome. If it was the desired or intended outcome, it would be murder. It would be murder, but we're not talking about cyber stalking murder. We're talking about cyber stalking and the potential consequences for it. Potentially could be different, but that's not how Congress wrote it. Because the resulting death can be caused accidentally and certainly negligently or recklessly, the death results element cannot supply the necessary use of force to convert the charged stalking offenses into crimes of violence. So remember, we're just focusing on the cyber stalking here. The murder requires the cyber stalking itself be the crime of violence. If we were just looking at the murder, it's easy. You intended to kill somebody. But that's not the focus. That's not how Congress wrote the law. Regardless of the mental state or lack thereof required by the death results element or reasonable fear element in isolation, the government next argues that viewing all of the elements together and in conjunction shows that the charged stalking crimes cannot be committed without the use, attempted use, or threatened use of force at some level above recklessness. The government concedes, as it must after Taylor, that this inquiry cannot be one of reasonable probability or plausibility or empirical likelihood of prosecution. Rather, a hypothetical scenario in which the crime can be factually committed without the use, attempted use, or threatened use of force at some level above recklessness need only be possible. That is, consistent with the laws of physics and the nature of human interaction. In other words, an exercise in hypotheticals is useful or determinative only insofar as it produces an example illustrating that an offense could be completed without force, because such an example necessarily shows that force must not be an element of the offense. So hypotheticals that prove you could do it with violence don't matter. The question is simply, is there any hypothetical at all that shows you could do it without? So that's the undertaking. And if there's any one of those, and you can't dispute that that would constitute a criminal, act under the statute, then you're losing your argument. You're out of luck. Apart from that potential use of hypotheticals, the categorical approach must focus on a crime's definition as expressed through its elements. And if the definition is missing the necessary component of force, the court need not worry whether it is difficult to imagine the absence of force in a real-life case. That was the job of the residual clause, which is now long gone. In making this, they talked about the residual clause in a footnote up at the beginning. It doesn't apply. It doesn't matter now. So I'm not going to get into that. In making this holistic argument, the government joins a handful of district courts and other circuits, arguing that there is no conceivable example of conduct that places the victim in reasonable fear of death or serious bodily injury, and that causes the victim's death, and that does not involve the threatened, attempted, or actual use of force. So it brings up all of these other cases. But this court takes a different opinion. Respectfully, the court cannot join this group. None of the cited cases conduct the rigorous analysis now required by Taylor, with its focus on elements and its express rejection of efforts to backdoor the now invalidated residual clause of Section 924C by musing about the way a crime is generally committed. Nor do any of them wrestle with the requirement imposed by Borden that the element or actus reus that satisfies the force requirement must be committed with a mental state greater than recklessness. But even putting aside for the moment whether such a holistic analysis that rejects conduct deemed too far-fetched is even permissible as an analytical frame after Taylor, the court also disagrees that it is impossible to imagine how a defendant could commit the charged crimes without the legally required use of force. I mean, I think we just gave an example. I do all of the things required to stalk you, and I'm following you. I'm following you around. I mean, I've used this kind of stupid example with the tossing a knife, but I followed you around, and I'm tracking you in the car, and I'm doing this with the intent of you knowing that I'm doing it so that you'll be afraid, and that you will be distressed, and you might be worried that. Maybe I'm revving my engine, gonna hit you with the car. And then out of nowhere, somebody comes up behind me, hits my car, and my car gets pushed into you and you die. It's but for cause. But for me doing those things I was doing with my bad intent, you wouldn't have died. But is it criminal? Got to get the recklessness imputed there for it to be a crime. Me revving my engine, maybe I'm on the wrong side of the road. I'm on the wrong side of the road. I've been like driving past you to yell out the window. I'm gonna get you. Vroom, vroom. Somebody comes around the corner, hits me, knocks me into you. It's pretty reckless. Is that going to count? Is that super far-fetched? The key point is the one we have made above. The statute does not require as an element that the defendant have the subjective intent or even knowledge to place the victim in fear, consequently to cause reasonable fear with conduct that nonetheless is undertaken with a specific intent to harass. All it takes is a difference in perspectives between the offender and the victim. And to cause a death, all that is required is an unintended sequence of events that makes an already bad situation take an irretrievable turn for the worse. So, does my example cover it? Kind of think it might. Maybe she'll give us one. Look, she's going to. In sum, a defendant could complete the charged travel stalking and cyber stalking offenses only reckless conduct that falls short of the legal definition of use of force against the person or property of another. A hypothetical case proves the point. Suppose a man travels across state lines with the intent to harass an ex-lover that he believed had been unfaithful to him during the relationship. Nothing about the man's history with the victim suggests a propensity for violence, and he harbors no intention of causing fear. Rather, he seeks only to turn the tables and humiliate the victim. He fantasizes about achieving a sense of closure by ultimately confronting the victim and relishing the sight of her shame and embarrassment, or hopefully her guilt and remorse for her past conduct. The man starts with indirect tactics. He travels from the neighboring state where he now lives to secretly post signs at the victim's workplace reading, "Victim is a slut and a cheater," and also sends an anonymous mass email to all of her coworkers with the same message. He pays a sketchy friend of a friend to follow the victim with instructions to occasionally shout, "Cheater," or to talk loudly with other patrons about her past infidelity when she was out with friends at a bar, and to text him updates on the victim's whereabouts and mental state so that he can best plan his own in-person confrontation. Is this court watching the Jim Martin trial with me? Christy Martin's attack? Maybe. Not sure. So far, so good. The defendant has traveled and used the internet with the intent to harass and has engaged in more than one act in the course of doing so. The man is confident in his own mind that his planned course of conduct does not go too far and veer into any kind of violence or threat of violence. But what if the victim sees things differently? In all kinds of circumstances, the man may unknowingly place the victim in reasonable fear by consciously disregarding a substantial likelihood that his actions would produce that result. He may, for instance, wrongly assume the victim will readily attribute the anonymous messages to him, ignoring that his anonymous accusations of cheating could conjure fears of potential violence from other actors. Perhaps the man knows but disregards the fact that another intimate partner, also suspicious of infidelity, had recently threatened the victim with violence, or that an unstable coworker had promised physical retribution after accusing the victim of using underhanded tactics to win a coveted promotion. Or he might discredit or ignore warnings from his friend that his shady henchman has a history of erratic behavior leading to a rougher treatment of the victim than the man intended. Or maybe the man simply lacks awareness and good sense, as stalkers generally do. Based on an amicable history with the victim, he may assume the victim has no reason to perceive his actions as threatening. Or he may be so freaking deluded he thinks this is gonna win her back. He might be so deluded, he thinks this is going to win her back. But he may fail to recognize that his conduct departs so wildly from accepted norms that any existing benefit of the doubt would almost certainly give way to an updated presumption that he had gone off the deep end. He might, for example, trespass into private places to leave notes or post signs at the homes of the victim's friends and family. The man's only intent is to maximize humiliation and maybe get an apology. But from the victim's perspective, one that is objectively reasonable, the man has unintentionally conveyed an ominous warning that she may be in serious danger and there is no place to hide. "I know where you are" is potentially threatening. It's just the kind of thing that, does that seem reasonable? Following you around, I know where you are. I'm targeting you. Is that threatening? physically threatening. You can kind of see how it would be. If that's not enough, suppose the facts get worse. Ready for his big face-to-face moment, the man eventually relays a final anonymous message: "We need to talk." He then drives to the victim's house, parks on the street out front, and sits in his car while waiting for the victim to come home. 10 minutes later, he spots the victim's car approaching from the rear, and at the same time, the victim takes note of an unfamiliar car parked in the street ahead. The man begins to open the car door, and the victim deduces that the person must be the anonymous harasser, ready to pounce. In a panic, the victim turns the car around and begins driving towards the nearest police station. The man starts his car and follows close behind, anxiously seeking the final confrontation of his fantasy. The victim apprehends that a chase has begun, and the panic grows. Distracted and having accelerated too quickly, trying to catch up to the victim, the man loses control of his car after the victim abruptly brakes to make a left turn. Through her side window in the middle of the turn, the victim can see the man's vehicle barreling straight toward her at speed, seemingly to her, intending an inevitable direct impact with her car. If she did not previously fear serious bodily injury or death from the conduct up to now, she certainly does at that moment. The cars, in fact, collide. The victim is mortally injured, and she dies at the hospital shortly thereafter. This is remarkably similar to my car accident hypothetical I came up with. The facts of this hypothetical case satisfy every element of travel stalking, and cyber stalking is charged in counts 1 and 2. The man traveled and used the internet with an intent to harass the victim. He engaged in a course of conduct that placed the victim in reasonable fear of death or bodily injury, certainly by the time the victim apprehended the car crash, if not far earlier. And as a result of that course of conduct, the victim died. Yet at no point did the man engage in conduct that, under the rule of Borden, constitutes the use, attempted use, or threatened use of physical force against the person or property of another. At worst, he acted recklessly as to the effect of his actions. Every threat the victim possibly perceived was the unintended result of the man's disregard of a risk, as was the victim's death. The hypothetical does not strike the court as especially implausible, not that that counts for anything under Taylor. Implausibility doesn't matter, just hypothetically consistent with human cognition and the rules of physics. To the contrary, the hypothetical case illustrates the characteristic nuances of stalking as well as the rationales for a broad definition of the crime. So that's it. She can imagine a way where it can be convicted without ever having to use threatened, attempted physical force, violent force. So it's not going to count. It's not a crime of violence. The defendant's final argument is that because the Romanet subsections listing the third-party proxies for the victim are only means, and because a perpetrator may fall within one of those categories and commit the crime by placing the stalking victim in reasonable fear that the perpetrator will harm themselves, the crimes cannot be crimes of violence as a matter of law. This argument follows from the requirement that to be a crime of violence, the defendant must use, threaten, or attempt physical force against the person or property of another. I've used this argument before, not obviously in this specific context, but similar context. The court agrees that the reasonable fear element could be satisfied by a threat to inflict self-harm, which cannot satisfy the requirement for use of force against the person or property of another. On this point, the court adopts the reasoning of this case Plunkett as filtered through the court's own analysis above. Plainly, a threat to use force against oneself or one's own property does not meet Section 924C's force requirement. Because the reasonable fear element covers placing the victim in fear of the death of an immediate family member, spouse, or intimate partner, a perpetrator who fits into one of those categories could satisfy the elements of the stalking offenses by threatening self-harm. I'm your spouse. I'm going to hurt myself. It technically fits under the cyber stalking statute, but it's not enough to constitute a crime of violence. Examples are not hard to come by. For instance, a woman's estranged husband could travel in interstate commerce with the intent to harass her, and in the course of doing so, threatened to shoot himself if she refused to meet with him. Stuff happens all the time. So common in abusive relationships. Threat of self-harm, self-sabotage, etc. They rely on the inclination of people who are maybe a little too good for their own good to put other people first, to put their needs above your own. You don't want to be in this relationship anymore, and it's not good for you, and it's unhealthy for you. But if you leave, this other person might hurt themselves, and so you stay because you put their needs above your own. This is so common in this abuse dynamic. Similarly, a man's daughter could travel in interstate commerce with the intent to harass him and, in the course of doing so, threaten to take an overdose of pills if he did not agree to do something that she demanded of him. Plunkett did not involve a death results element, but for the same reasons explained earlier, a death of the stalking victim resulting from a threat of self-harm by the perpetrator would suffice. For example, a stalking victim may attempt to wrestle a gun from the suicidal spouse in the first Plunkett hypothetical, only for the gun to accidentally discharge and kill the victim. It was a P320, guys. That's it. End of the story. The government's primary argument against this interpretation is that it would be absurd or run counter to Congress's intent in drafting the statute. Neither of these analytical frames are relevant to the court's analysis under the categorical approach. The fact that you think it's stupid doesn't matter. The court has said it doesn't matter if you think it's stupid. It just matters if it can comport with the laws of physics. That's it. But even if they were, the court cannot agree with the government's arguments. First, the government argues that threats of self-harm should not qualify because harming yourself, whether by suicide or by deciding to end life-saving medical treatment, is not itself criminal. And allowing self-harm to qualify would risk criminalizing innocent conduct. For the reasons noted above, this is not persuasive. Earlier elements of the crime, such as travel with intent to kill, injure, harass, or intimidate, suffice to separate wrongful conduct from innocent conduct. Second, the government argues that including the perpetrator in the definition of immediate family member would mean that other statutes, like 18 U.S.C. Section 115, that criminalize threats to assault, kidnap, or murder a member of the immediate family of a United States official, would not be crimes of violence either. But most of those statutes contain language that solves this problem. For example, you cannot assault, kidnap, or murder yourself. And to the extent they don't, the court takes no position on what a thorough analysis of those statutes would reveal about whether under Supreme Court precedent they do not qualify as crimes of violence. It's not before the court, so you don't have to decide, the entire universe of the law to address your particular issue. Third, the government suggests that reading the statute to allow the victim's fear of injury to the perpetrator to qualify would pervert the statute's animating purpose of protecting stalking victims from perpetrators. But the reality is that family violence and intimate partner violence are complicated. Victims often remain in relationships with perpetrators, and love and affection on the part of a victim can persist towards an abuser, even where the victim chooses to end the relationship. If anything, including threats of perpetrator self-harm, is more consistent with the broadest protection for victims. Yeah, it is. It's extraordinarily manipulative using that threat of self-harm because it's kind of like the ultimate blackmail for somebody who will always put somebody else's needs ahead of their own. Like, how do you trump that? You can't trump that other than one-upping it. Nobody wants to do that. So for the foregoing reasons, the defendant's motion to dismiss counts 3 and 4 of the indictment is granted. And we have made it through the opinion. Is it clear now? Is it hopefully a little bit clearer? She did warn us, right? She did warn us. This is going to be kind of crazy and it's going to be counterintuitive. But at the end of the day, the simple reason is that if you can imagine a way that you can commit this crime of cyberstalking that doesn't involve physical force, using, threatening, or attempting physical force, then it doesn't qualify. So it has nothing to do with the allegations specifically against Luigi in this case. only has to do with what you can imagine in the universe of what the elements of that charge permits. And so because she has imagined these hypothetical scenarios in which a person could be convicted for the crime, but not use physical force as it's defined in these various ways, it's not going to count, not a crime of violence. So without cyber stalking, without interstate travel stalking being a crime of violence, then murder that is committed in the course of committing those crimes isn't a federal crime. It's a state crime. And so that is going to then kick us back to the state case. I mean, obviously, we're still trying the two charges here in federal court, and they do have potentially very serious consequences, potentially serious punishments. But as far as just whatever, I don't know, PR or kind of prestige upside you want from a murder conviction, they're no longer going to get that in federal court. And then as a result of that, because murder is the only way to get death is off the table. Can't do it. So they are stuck with the murder prosecution in federal court, in state court, and then the potential consequences you can get from that, which is barring exceptional circumstances. I think it's 15 to 25 years. But then with exceptional circumstances, it can be up to life without parole. So interesting turn of events. And hope you guys maybe understand now why I wasn't like bending over backwards to want to analyze this one before the decision came out. Because the analysis is a nightmare. Welcome to the world of criminal defense and the crazy, contorted thought processes you sometimes have to go through, and just in the hope that you're right. The problem, part of the problem, when I'm dealing with these things in this context is, okay, say I'm analyzing a plea deal that my client's been offered. And so I need to imagine hypothetical scenarios where this crime would not constitute a crime of moral turpitude, right? And I imagine that hypothetical. So I'm like, okay, it doesn't count, so it's immigration safe. We'll go ahead and do the plea. So he does the plea, and then a couple of years later gets picked up by ICE, and they're like, oh, you got this. I'm going to put you through the removal process. And he gets a different lawyer. He gets an immigration lawyer and stuff like that. And that lawyer doesn't think of the same hypothetical that I did. Like, my thought process is not law. It's not binding. It's not authoritative. It's nothing but a prediction of what would happen in the future, barring a decision that's already out there that says this specific Washington crime is not a crime of moral turpitude. And so, prediction doesn't just involve this abstract world of evaluating elements and so forth. It includes this very pragmatic world where people have, different caseloads and different capacities to sit and think and imagine different things. And you've got different judges receptive to, the arguments and so forth. So this makes it quite tough. And this may also help to understand a little bit why perhaps there is a little bit of a public defense crisis, because who wants to have to do this and to fall short? Are we getting paid for that? Like, really? It's some pretty complicated stuff to be getting into. When you often barely have time to meet your clients and chat about the facts before you decide if you're going to trial or not. So with that, guys, my goal here was to hopefully, besides just sharing a little, context about how these things all intersect with, my own practice, why I knew this is a nightmare and it's not going to make a lot of sense to people. My goal was, in fact, to try to help clarify this analytical process, and whether or not we agree with it, because that, of course, is a different question in legal positivism land. The existence of the law is one thing, its merit or demerit another. Seems to be pretty clearly what Judge Garnett is saying right in the introduction of that opinion. She is making a profound legal positivist disclaimer. I didn't make this. I think it's stupid, but it is the law. And so my goal was to hopefully help clarify both what exactly that means, maybe a little bit about why it is that way, but also, the part about it being stupid. Like this is a whole other way that you may not know that it's stupid, but just on its face may not make a lot of sense, but it also creates some real challenges in the trenches of practicing criminal law. So that was quite enough for this particular decision. I am also going to move on and talk about the ruling on the motion to suppress. I'm going to do that in a separate video. Probably won't be this long. It also probably won't be this convoluted. But what I'm particularly interested in is the way that it is not necessarily helpful with the state case, like what the decision tells about us in terms of the potential outcome from the state motion to suppress. So that will be coming up very shortly, guys. In the meantime, we get more news about the case, maybe clarity about what this upcoming hearing on the 6th is going to be. You can check my Twitter for things like that. So I will keep an eye open and keep you posted as meaningful things happen. So thank you again for joining me. Appreciate all of you being here. I hope this one was helpful, and I will see you guys soon.